Hopefully this will be some interesting stuff. Social media, the use of social media, I must admit to y'all that I am a Luddite when it comes to technology. So a lot of the lingo that's used in this sort of realm is not an area of language that I'm comfortable with, and I often find myself talking to my 12-year-old daughter to get sort of a sense of what a lot of this means. The other part of this is that for those of you who use social media or have children who use it, and are trying to stay on top of it, it's always changing. I mean, there's always a new platform that's out there that's being used. And so this whole area of social media, how it's used just in general, is hard to kind of keep a handle on, but then when we talk about it in terms of ethics and lawyers' use of social media, and at the very end, as Josh mentioned, I will talk a little bit about the most famous tweeting judge, which when I first heard that there was a tweeting judge, I was just incredulous. I thought a judge is tweeting. And I sort of ignored that whole, didn't want to sort of accept the idea that that's what's happening. But it is happening, and the more I looked into it, the more I am just curious about that area. But so I'll kind of wrap up the hour, or actually 45 minutes. Having served as chair of the Kansas CLE Commission, we go 45 minutes. Then I give you 5 minutes to ask questions, and we're out of here. My materials hopefully will be at least, I'm not going to be able to cover all of everything that I have here. It can be a 2-hour presentation, but I will be very respectful of the time, because I know that lawyers want that. And if you have questions and you want to follow up with me, you can always find me on the KU Law School website. And I do get calls and emails occasionally that I'm happy to answer. So moving along here, just to kind of give us a little bit of groundwork here in terms of getting started, the model rules of professional conduct there was a major overhaul back starting around 2000. The APA took a look at our ethical rules. The idea behind the overhaul was technology and trying to figure out how we could fit technology into our rules. And the purpose of this presentation, I do a presentation on that itself, but I do want to talk a little bit about what was done to give you some context of what we're going to see for the next 45 minutes or so. There was a major overhaul in technology, and probably the biggest change was the terminology, actually 2 big changes. One was defining a writing, and what a writing is when we look at informed consent, confirming informed consent in writing that you see throughout the rules. And that particular definition was amended to include technology and changes in technology. And so writing includes not only sort of, ink on paper, but it also includes an electronic sound like a ping. It includes a symbol like an emoji. It includes all the things that we see in social media and platforms, so to speak. So that was a huge change. The second change that I think is also instrumental is Rule 1.1, competence. The language of the rule itself did not change, as I'm going to talk about, is that the language of the rules have really not changed, but there's been recognition of technology. And if you look at comment 8 to Rule 1.1, that particular, there's a new comment, and it relates to competence, and it says that a lawyer shall be, and should be, actually not shall, but it suggests that it should be very well versed on the risks and benefits of technology. So the comment strongly suggests that the lawyer needs to understand technology in terms of legal practice and representing clients, so on and so forth, and it goes to competence under Rule 1.1. So we're going to see that as we go throughout the presentation today. Many social media platforms are out there, and as I already indicated, they do change. We get new ones, and it's one of those areas that you have to stay on top of. There's a lot of uncharted, I guess I call it uncharted waters, relating to a lot of this social media and how it's sort of progressing and how it's affecting the law and legal practice and so on. But here are the top sort of ethical pitfalls that have been identified through various commentators and what I've been able to track on this particular topic. Lawyers using social media to informally investigate parties and witnesses. I'm going to talk a little bit about that today. lawyers using social media to formally investigate parties in a case, lawyers posting about a client or a case or a judge. I'm not really going to talk about that a lot today. I just want to I want to sort of remind y'all that when I do look on Facebook and see what lawyers are posting, sometimes I'll see lawyers posting, I know that their lawyers are posting about a case or had a bad day before, and what you're risking is, first of all, I think it may be unprofessional, so it's just, that kind of goes into that realm, unnecessarily unethical, but what you do risk is the breach of confidentiality under Rule 1.6. So if people, so the viewers, whoever's that's looking at your Facebook page can identify who that client is and sort of figure out, what case you're talking about, that's definitely a breach of confidentiality. The other thing I've seen, at least on one occasion, is criticism of a judge on Facebook, and you got to be very careful with that. So there's not a lot to say about that, except that's just something that you need to be sort of aware of, and it's interesting that there's lawyers who do these kinds of things on their Facebook page. Lawyers using social media to gather information about prospective jurors. This is actually a very, very hot topic across the country. There's a couple of opinions issued by ethics, by bar associations. I think out of New York actually has been pretty prolific in that area, and so we'll talk a little bit about that. Advising clients about their own social media presence, especially when litigation begins, and so the idea of taking down a Facebook page, is it foliation, is it destruction of evidence, there's all sorts of ideas about that. And then lastly, what I'm going to wrap up with is judges using social media, and I will tell you, as I indicated, I think that I have not covered judicial ethics at all, really. I mean, I'm aware of it, obviously, because I teach it at KU very broadly. But when I did a CLE presentation on this issue, probably about 6 months ago, I had a lawyer ask me about the tweeting judge, the famous tweeting judge, Don Willett, I think it's Don Willett out of Texas. And so he's actually, I'm fascinated by him now that I've actually delved into it. Josh asked me about him, and I thought, I really got to look at this guy. So I did, and I will wrap up talking a little bit about what I've learned so far on that particular topic. Important things to sort of think about here is that we are, as of 2012, which is probably the last comprehensive study that I could find, at least, everything that I was looking at in terms of getting you some more recent numbers went back to that 2012 study, so there's probably something that's more accurate, I don't know. But what I have is that 65% of adult online users use at least one social media platform, whether it's Facebook, LinkedIn are very, very popular. And I provided a recent, actually, from the Pew Institute. That just, in 2016 in November, they did a study and said that research showed that 80% of online users use Facebook. Almost 30% of online adult users, especially those are professionals like lawyers and businesses, use LinkedIn. So those are pretty big numbers. And before I move on here, I want to kind of stress I think two very important points that I've kind of put there in that PowerPoint. And it is what I've seen consistently in all of the ethics opinions that have been released and in all the various writings done by legal experts, is that it's easier to violate rules in cyberspace than it is in person. And then probably the second most important point is that, and I've already indicated to you, while the model rules of professional conduct that are, of course, adopted by the ABA, and then states can adopt them or tweak them or however they want to go about implementing them, do not expressly mention or account for social media anywhere. So it's not mentioned anywhere in our rules of professional conduct. Similarly, with the canons of judicial conduct and the rules that were within those canons, there is no express mention of social media at all. All right, you can see there's a litany of model rules that are implicated by using social media. And so I just thought I would kind of put those out there for you to see. And we're going to be, as I go through these various ethical pitfalls, highlight some of these rules that are clearly implicated through the use of social media, depending on the context of how lawyers use social media. I've already indicated the competence under Rule 1.1. The language of the rule itself was not changed. We have comment 8 that was added, and it suggests again that lawyers be very well versed in the risks and benefits of advances in technology, but the rule that lawyers shall be competent remains the same. Diligence, I mentioned on that as well, because usually when you talk about competence, you talk about diligence, those two particular rules go hand in hand in representing clients and doing client advocacy. Truth and statements to others, again, the language of this rule hasn't changed either, but the essence of this rule says that a lawyer shall not knowingly make a false statement of material fact to a third person. And there's been legal commentary to suggest that when you friend someone on Facebook, like a witness or a party, or someone involved in litigation, what you're really doing is something to that of that nature. 4.2, communication with persons or with a person who's represented by counsel. Again, if you're going onto a public Facebook page and you're in litigation and you know that particular party has a Facebook platform, for example, like Facebook, by friending them, by doing a like or a follow, that could be having a communication that's not allowed by the rule. 5.3 deals with responsibilities of non-lawyer assistants, and this goes to the very essence of our agents who we have working for us, including our law clerks, our paralegals, investigators, so on and so forth, who help build the case for us and gather information about parties or about witnesses. Respect for third parties. This is actually fairly interesting in that the lawyer, the rule does not or prohibits a lawyer from using means that have no substantial purpose than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate legal rights of a person. To the extent this rule is implicated, it relates to usually to parties, but using the idea being that you're using the social media, gathering it for purposes of what I just talked about, which is not allowed by rule. But it particularly comes into play for privilege issues that can arise in litigation. So that's something that's been raised by legal experts as a rule that we need to think about. 3.5, impartiality and decorum of the tribunal. What this talks about essentially is that the lawyer cannot communicate or influence a judge or a prospective juror or a juror who's sitting on a panel. So if you use social media to do that, that's inappropriate. And then lastly, I always like talking and mentioning, not like talking and mentioning, but certainly I do because I think it's one of the important rules that does come up and certainly is cited by ethical opinions throughout the country, just about in any context of discipline, and that is general misconduct. I call it the catch-all rule, 8.4C, A and C, in that essentially A prohibits. It's pretty clear that the lawyer cannot violate, it's a violation in and of itself for the lawyer to violate the other rules of professional conduct. And then C states that the lawyer shall not engage in conduct that involves dishonesty or misrepresentation. Dishonesty and misrepresentation are triggered through the use or improper use of social media, like we've just talked about with these rules. All right, a little bit about the issue on informally, when we informally investigate parties and witnesses. I had this interesting discussion with my students in my pretrial advocacy class, and we're getting into the discovery phase of this pretend case that we were litigating, and immediately, in fact, we spent probably the whole one class hour, talking about their reaction. You're talking about law students who are, young, savvy, and have a very strong aptitude for social media. But the discussion was, the first thing I would do is when I go to see what's on, I Google this person, whether it's witnesses or parties, and I want to know who these people are, and I go to their Facebook page and blah, blah, blah. And so we started chatting about all this. And so that is that informal investigation of a case, and the answer is absolutely yes, right? Because you may not be in discovery. If you're in District of Kansas in federal court, we have a discrete discovery period. In your state practice rules, we can do it just about at any time unless we have a court order that says otherwise. with the idea being at the minute, we know we're going to be in litigation, we're going to start Googling people, and we got to find out who these people are, what's their online presence. And so, does it go to competence? And the answer is absolutely yes. I mean, I think that anymore, if you don't go online and figure out, Google, witnesses, potential witnesses, parties, lawyers, judges, and who are these people? What we got to learn about these people. It does go to competence. Rule 4.1 prohibits lawyers from making statements of material fact to a third person like a witness. So again, the contact on the social media platform is super important. Are you contacting them? As we're going to see as I wrap this up, the idea is that I think throughout the country, again, this is sort of uncharted waters, but I think the consensus is it's fair game if it's public. You can Google someone as long as the public, whatever's posted on the web, and you're not doing anything to mess with that, it's fair game. So anytime you're going beyond that, like even doing a simple like, or somehow if the witness or the party can identify that you are tinkering with or somehow looking at their page, that is considered contact. So that can be an area where the lawyer can say, I didn't intend for that party opponent, I was looking at their webpage or their social media platform, but I didn't intend for them to know it. Well, you cannot be ignorant and say I was inadvertent, I didn't know. So making sure that you're competent about that and maybe talking with someone who's well versed in how this all works is super important. 4.2 then again, it talks about the lawyer is prohibited from communicating about the subject of the representation with the person the lawyer knows to be represented by counsel. So we have rules that relate to people who are unrepresented, who are witnesses, and are not necessarily parties, because you can't appear to be interested. But you also have someone who's represented by counsel. That becomes super, I think, a little bit more dangerous. A little bit more on informal investigation. I think I've kind of covered a lot of this, making sure that anyone who's working for you under your direction understands that they're subject to the rules that you're subject to, and that they're competent with technology as well. All right, formal investigation is a little different, and the reason it's a little different is because there's some issues that are created, I think, because of formal discovery. So when I make a distinction here, I'm using it, I'm making the distinction in the context of informal discovery versus formal discovery, where we use devices such as a deposition, a motion, or interrogatories, those sorts of devices that we use in discovery. And we know that we need to do discovery. It goes to our competence, and so we will use discovery devices in representing our client to get information. So Rule 4.4, I just want to make sure I'm on the same page here. All right. To the extent that this becomes an issue, again, is that oftentimes when you're involved in litigation, what we find is that, of course, we want to know what's on a private page. Do we have access to that? Can we get access to that? And so what we're seeing, and this is to the extent it's a big issue, it is when lawyers are asking and demanding, either in discovery, asking for passwords and usernames and passwords to get access to a private platform. And interestingly, we have rules that we don't have rules that really sort of regulate this. And we had a situation come up in our deposition skills workshop this past year at KU, where the lawyer that was taking the deposition asked the deponent, who was a party opponent, for their username and password on their Facebook page. Well, so the lawyer who was workshopping the student said, okay, well, what do we do with this? Because if you look at the federal rules, we're using the federal rules, we didn't have a protective order in the case. There's no basis under the federal rules for the lawyer to instruct the witness the party not to answer the question. So I ended up getting this huge discussion about what can you do. Well, honestly, I think you need to have some sort of pretrial order, so it's clear that stuff's sort of out of bounds, and why would anyone turn over the username and password password for anything, including their social media platform. But anyway, this just kind of illustrates the issue and the problem with us not having rules that give us a sense of how to go about doing it. So the courts are fairly inconsistent, or they are inconsistent in how they treat motions to compel when a party refuses to comply with requests, depending what those requests are. Again, usernames and passwords are something that's kind of been a hot topic, and judges are all over the spectrum on that. So that's why I indicate some sort of pretrial order would be helpful on what's fair game. The use of business record subpoenas to compel discovery, I will tell you, is virtually unsuccessful, especially because you have Facebook, you have LinkedIn, they're lawyers, they are lawyered up, and they are doing everything they can not to turn over this stuff. So usually you're not going to get it that way. Probably the best way, again, to get information on private pages is through discovery, using your methods, but then of course being clear that having some direction from the judge and how he or she wants that to be managed. All right, so we've talked a little bit about competence, that goes to competence. You definitely, you need or are aware of private pages, private platforms that you believe are relevant to the litigation, and you want access to it, getting direction and making a request to the judge and understanding what those parameters are. Again, by law, there really isn't a whole lot unless you're in a jurisdiction that has those rules. You're kind of at the mercy, if you will, of the judge on those issues. All right, let me go ahead and keep it along here so that I can stay true to time. Gathering social media, using social media to gather information about prospective jurors. Rule 3.5 is implicated, again, because as I mentioned to you, we are prohibited from either influencing or communicating with a juror or a prospective juror. Again, 5.3 relates to your anyone who's a non-lawyer that's working at your direction. And we kind of emphasized how important it is, and sort of our immediate reaction is once we get a witness list or a juror list, because I'm talking about jurors here, what can we do with it? And so New York has been pretty prolific and sort of the pioneer in coming up with ideas and guidelines, and there's actually two of them. The first opinion that was ever issued was in 2011 by I think the New York City Bar Association. And then they issued a subsequent opinion, and when you read the two of them together, those opinions essentially say that it is ethical for the lawyer to undertake pretrial and ongoing research of a juror's public social media site. So it's got to be public once you get the juror list, and provided that there's no contact or communication. But then the opinion goes on to say, and I think give us the follow-up opinion, it says that the lawyer cannot act in any way in which the juror becomes aware of the monitoring. Now, interestingly, the opinion didn't give a sense of what the remedy or a sanction could be against the lawyer, but they made clear in the opinion, it was a pretty interesting opinion. They talk about technology, and they talk about how lawyers oftentimes, unless you're tech savvy, you don't understand that you could have this inadvertent contact and not even realize it. But the opinion itself was very clear that you can't have it, and that you could I don't know what could happen, but it was prohibited to have this contact, and I'm not sure again what the sanction would be. They stress that making sure you're technologically savvy, or that you have someone who can help you with understanding the platform and how you're using the platform is super important, because unless you have that kind of technologically savvy and you really understand what you're doing, you could get yourself in trouble, and that's really kind of what they indicated in their opinion. So let's see, what else do I have on jurors here? All right. What I could find on this after this is an issue that's come up with prospective jury selection, voir dire. We know that oftentimes it is very just within the realm of judicial discretion, and judges have obviously been grappling with this. Most jurisdictions or courts do not have any set rules about gathering information about prospective jurors. The Kansas Supreme Court, if you look at their rules related to district court practice, has nothing about this particular area and any guidance on that. The District of Kansas, I did get a chance to look at the federal rules and on whether DCAN has anything. There may be specific judicial standing order, judges who have standing orders about this, and how they conduct and release particular jury lists or potential jury lists to litigators or litigants. But this is an area that, again, is very, I think, a very big hotbed for discussion. One of the areas, though, that I've been able to look at is, do we have any sort of guidelines? And there's been a few different opinions about this or commentary about what is ethical in terms of conducting any investigation on potential jurors. And I've come up with actually 3 that I think make a lot of sense and that I wanted to share with you. The first is, and this is sort of taken from the New York ethics opinion, you follow the open to the world public content rule. So you Google your prospective juror, whatever pops up, you look at it, you don't click, you don't do anything. However that's possible so that you get a sense of who your prospective juror is probably okay. The second recommendation, actually, I think is probably the safest recommendation in terms of best practices, and it's what's been called as the reasonable webmaster rule. And this reasonable webmaster rule is this new sort of terminology that's used to describe the expectation or the standard, I should say, that lawyers should use when engaging in using social media platforms in any context. It's more technical than the open to the world or public rule. It's much more technical and it's much more involved. And what it does require is really this high-level technical knowledge that really comes from the lawyer, either having that kind of knowledge or working with someone who has that, like a webmaster. That's what they call it, the reasonable webmaster rule. So the idea being, and when I think about myself and being a Luddite, I know that I would probably pull, because I'm just not versed in this kind of, these platforms, and it's not intuitive to me at all. I could see myself inadvertently doing something that, a prospective juror, even a party, a person who's represented by counsel or a witness may say, oh, she contacted me. I'm like, well, I never intended to contact her, I just wanted to pull up your public profile. So, but the reasonable webmaster rule is very safe because you're then taking essentially advice of someone who is technical, who is very savvy, does know these rules under this particular standard. Again, much more involved and much more technical. And then lastly, in terms of best practices, is ensure that your agents are following your rules, follow these rules because they're bound by them as well, because of 5.3. All right, transition over to advising clients about their social media presence. This is a really, really big deal. And this kind of turns the tables a little bit about onto looking at what do we tell our clients about this? What kind of legal advice do we give them? So based on statistics, we know that I've just covered at the beginning of my presentation is that your client in any case, will have a social media presence, okay? And it's going to get a little murky when you've got a personal presence and you may have a professional site versus your personal site. So those areas can create some blurred lines concerning relevance and sort of accessibility and discovery. But I think it's absolutely critical, and it goes to confidence, and it goes to just making sure your client is protected, that you have these conversations about, social media platforms, so that you understand where they're posting, how they're posting, in what context they're posting, because it may or may not be relevant to the litigation that's going on. So it does go to 1.1, it does go to 1.3. It's also very important to give your client advice that I think it goes across the board, that there is no right to privacy on social media if it is public. So any public Facebook page, any public LinkedIn, anything that's out there where you can just Google this person, we've already talked about how to do that on the other side of things, that is fair game. There is no right to privacy. When we get to public or private, if you will, pages, we've talked a little bit about the difference in that and how it may be treated a little different because it isn't for the world to see, but that doesn't mean it's not subject to discovery. And what we have seen is that judges across the country have allowed access to private pages as long as whatever information the other side is seeking is relevant. So even their private page may not be protected and may be subject to formal discovery, so they need to understand that as well. The last point I want to make on this goes to 1.2, which actually goes, it's a provision with scope of representation that prohibits the lawyer from advising or assisting a client to engage in fraudulent or criminal conduct, which is, in this case, potential destruction of evidence, or destruction of potential evidence, I should say. So let's talk about this a little further here as I'm setting this up. The other, I think, important point in advising clients is that because we know that our ethical rules do not expressly discuss social media. Again, we've talked about advances in technology, but doesn't expressly recognize the use of social media. We need to sort of approach and advise our client about social media as if the platforms do not exist. Okay, so for example, I mean, when the client is out there communicating and talking, what we're seeing here is that the social media platform is that. It's basically talking to whoever it is that they are posting out there to, whether it's 500 friends, 50 friends, the world, whatever. So it's basically a communication that the client is making. So what do we do in advising our clients about this talking to the world? Well, I think it's consistent, at least in what I've read, that it's okay to tell your client to shut up, right? Quit talking, right? In other words, quit posting. So that across the board is, I think, acceptable. It is not okay to delete postings that are relevant to litigation, and we've seen when this issue was kind of started to show its horns. There was a question about spoliation of potential evidence. By deleting it, is that what's happening here? And I think that initially there was some hesitation for courts to make those findings, but I think that what we're seeing is that anymore, the judges are not happy with that. The idea that you could have relevant information on a social media platform that is being destroyed. And to give a very good example of this, I did an ethics presentation on this topic for a law firm, and the lawyer in that case does a lot of insurance defense. And when the case was was filed, the lawyers immediately got on social media and were looking at the party that was injured. And what they found was that this of course, plaintiff's claiming all these injuries in court, and they got on immediately when they were assigned the case and took over the case, and they took shots of the Facebook of this particular plaintiff. And the plaintiff was skydiving in Costa Rica. Okay, so then what happened? Cha-ching, defense wins. What's the injury if you're saying you have all this physical injury and all this, and then you're skydiving in Costa Rica? So then what happens as the case goes on? They took snapshots of that, so they had that. The lawyer who was representing the plaintiff instructed the plaintiff to take down their Facebook page. And so this was litigated. It was on Missouri side, and the judge issued sanctions and everything because they found out that the lawyer had advised the client to take down their Facebook page. And the judge said, that was relevant to this case. He ordered them to take it down, and they issued some sanctions against the lawyer on that. So, that was handled in court, but it's still a problem that you want to be aware of. Okay. So shutting down sites. Can you shut down a site? So not take it, not just. There's all these. What if this? What if that? You have some judges who say, well, you know, it's okay to shut it down because we're going to view it as a communication, and so the client, you know, this party has spoken at some time but no longer wants to be heard. So that's okay. On the other hand, it could be spoliation. So again, this is an area that's still kind of out there that really hasn't been resolved. Certainly Kansas hasn't resolved it. We don't have rules that resolve it either. So something to think about. All right, my last topic, I think I'm right on time too, but I'm pretty excited about. Right. Judges and social media. So, as I indicated earlier, the area of judicial ethics, I cover it in professional responsibility very, very briefly. Most of what I cover in my class, it's a 2-hour class, is the model rules of professional conduct when students are tested on that. They do have questions on judicial ethics, but a bulk of what they will be tested on the MPRE is related to lawyer conduct. So I've only covered it very broadly for purposes of that, of teaching to the rules for students in professional responsibility. But the issue of judges and social media has always been a curiosity to me, and I think it is a curiosity to most people, and the idea being that when we think of judges, we think of you know, folks who obviously sit and make decisions about cases, and I think the public in general views judges as been living or being shut off in a room somewhere, and then they come out of the room and then they issue decisions, but the idea being that they shouldn't have, you know, they have to be very impartial, they should be engaging in a lot of what's going on in pop culture and in politics and those sorts of things, which is understandable. So there has been lots of litigation. When I say litigation, I should just say mostly some questions about judges and social media and their ability to be more public figures in terms of being out there and having a social media platform. And this is what I've come up with. So I thought I'd share with you what I know so far. And then I'm sure this is going to continue to evolve like everything else. So there's probably 3 or 4 different ethics opinions about judges as this whole issue started to sort of evolve, whether a judge could even have a Facebook page. So there was debate about that the judge, once you're a judge, you shouldn't even be on social media. So that's how a lot of these ethics opinions started out. And I think what's consistent is that there is no prohibition on having a social media presence. And as we're going to see, a lot of that relates to First Amendment, the First Amendment protection. Judges do have First Amendment protection based on cases the Supreme Court has decided. I'll get to that in just a second. But the ethics opinions also suggest that the burden rests with the judge to ensure there is no impropriety, like with Facebook, LinkedIn, so on and so forth. And the concern has been that litigants may feel that, okay, well, if the judge is friends with this lawyer and, you know, so, and not this lawyer, or doesn't accept my friend request, you know, what does that mean? You know, all of a sudden people are paranoid about that. So if there's ever a question about that, the impropriety or the appearance of impropriety, then the opinions clearly suggest that can be questioned if the judge has the burden to show that there really wasn't. There was no intent here, so on and so forth. I have had a judge tell me once that I just friend anybody who asks me to friend them, just because if they want to friend me, then I'll friend them, because I don't even want to draw that line. That way, if anyone ever challenges me, I can say, I just friend whoever wants to be my friend, and so on and so forth. So. The ABA had an opinion that was issued in 2013, and that was a helpful guide, I think, in terms of giving us a sense of what judges can or cannot do. And essentially what the ABA did is it really kind of took some of these other opinions that started out early on and really were trying to constrain judges from having any presence at all on these platforms. And the ABA said that their use of social media, judges' uses of social media doesn't compromise their duties, but they are bound by the Code of Judicial Conduct, which is no kidding. So anyway, so we have the code or the canons, and then of course within the canons, the rules that sort of help flesh out the canons. So Florida, the state of Florida is an interesting state because they have been very, very restrictive. So they're, in terms of all the states that have looked at this topic, they had an opinion in 2009 that said that lawyers and judges cannot be friends on Facebook. So that was out of the state of Florida. Florida also had a case where the Florida bar went after an attorney who had posted on social media. I don't remember what he did, but they've been pretty aggressive about social media, how it's used. They're trying to control it from lots of different angles. Judges in particular are an area that they have really been trying to sort of restrict. And so that was their opinion in 2009. So like our ethical rules for lawyers, judicial canons, and the code of judicial conduct, at least the model rules, and Kansas has adopted most of those same rules of the model canons and model judicial code that the APA has implemented, don't expressly talk about judges and social media. So I want to wrap up and talk about probably the most, I guess, the rock star of judges who tweets and uses social media platforms, and that's Texas Supreme Court Justice Don Willett. Does anyone follow him here? Does anyone know what I'm talking about? All right, I'm going to follow him too because I think he's quite entertaining. So a little bit about Justice Willett. He's on the Texas Supreme Court. I think he was appointed or at least elected during the Perry administration, Governor Perry's administration. And here what I did is I took a snapshot of his Twitter page, I think 2 days ago, so this is fairly recent. I want to point out to you that he's got 88,000 followers. And it looks like he has tweeted, it's hard to tell whether this includes retweets or it's just his original tweets, but over 25,000 tweets. What I find most entertaining about him, he's very entertaining, but look at his description of his profile, I guess. He says he's Supreme Court Justice and Tweeter Laureate of Texas, former rodeo bull rider, fluent in legalese, an extravagantly blessed husband, and co-founder of 3 Lee Willets. If you Google him, there's tons that's been written about him. We have David Latt of Above the Law, who's a blogger, who's interviewed him. He's been talked about in New York Times. There's been an op-ed about him. And so a little bit about Justice Willett. He's been deemed the most avid judicial tweeter in America. I'll give you some examples of his tweets, and this is really kind of why I find him entertaining. He'll post stuff like, daddy-daughter breakfast dates are the best. Remember, he's constrained by 140 characters, so he talks about his family. He does make some, political commentary. He talked a little bit about, he tweeted, when it comes to legislating from the bench, and hyphen, I literally can't even. Okay, like that. But this is my favorite one here. This one he tweeted on September 8th, and he included a photo of 2 federal judges, which they were not happy about. But his tweet was a picture of 2 federal judges, and he just endured the way it's described here in this little article that I'm kind of quoting from here. So the 2 federal judges are enduring oral argument, and it's described as one being half asleep and the other apparently picking his nose. And he tweets with the photo, "This is why some judges," and he puts paren, open paren, not me, close paren, "resist cameras in the courtroom." So he is an interesting guy. He's a prolific judicial tweeter. And so one of the questions that's been asked of him numerous times is, why do you do it? And do you appreciate the perils of what you're doing? And he says, I do. It's like being a flying Belinda. I do understand that there are some perils, but He does say that he does avoid partisan commentary, and he does, of course, refrain from providing any commentary about legal issues that are in front of him or giving any sort of sense of comments about cases that are before him or making comments about the law in general. Why does he do it? It's pretty simple for him. He's an elected judge. So in Texas, he serves a 6-year term. He wants to connect with younger voters. He feels like he's doing that, which I think is true. And he is not backing down from doing it. So he does it because he wants to connect with his voters. He wants to stay on the bench. He believes by tweeting he's going to be able to do that. Heck, he's got 88,000 followers, and if you all start following him after today, he'll have more. And so he even goes so far as to say is that it's political malpractice if he does not use social media, so that's why he uses it. Is there a difference between elected judges and state judges? I think that's absolutely what the heart of this is about. There's legal commentary to suggest that if you're an elected judge, of course, you have to be elected and you have to make sure that you get those votes. In Kansas, as we all know, we don't have an election of judges. We do in some of our district courts, but our appellate courts are subject to retention. Is that a form of election? And the answer arguably is yes, because you're put on a ballot and the public can oust you out if they decide that they don't want you on the bench anymore. And we've all seen what's happened with that in recent years with our judiciary. So the question is, should judges be tweeting? Should judges be doing this and having a presence? And that's a question I think that everyone, that's sort of the question of the day. But I will tell you, I think the question really gets to, judicial independence, integrity, impartiality, or appearance of impropriety. And there is a clear difference between judges who are elected, I think, maybe not so clear, but those who are appointed for life. Is that necessary for you to be tweeting and so on and so forth? Clearly, Justice Willett believes that he's doing the right thing. As he has said, it's political malpractice for him not to do so since he's an elected judge. And lastly, I will say that there's been there's been challenges and questions about whether judges should be doing that, engaging in this kind of conduct. We do have the various cases in the United States Supreme Court, starting out with Minnesota versus White, which is a 2000 case that essentially says that judges do have First Amendment protections. There's some boundaries. What those boundaries are maybe still in question. But they have a right to speech, and this is political speech, which of course is very protected. And I think Justice Willett's a smart man, and he realizes that, appreciates it, and he's done, I think, a quite amazing job of putting himself out there, keeping himself visible, and letting followers and his voters, quote-unquote voters, know who he is as an individual and a human being, which I think people really like. They get to see sort of the human side of who he is, and it's actually quite funny if you follow him. He's a very funny guy. So, unless there's any questions, I think we're right on time. Great. Thank you.